everyone. Welcome on behalf of Women in the Refugee Law Network. So, as many of you realize, international refugee law and accompanying frameworks and initiatives can seem remote and impenetrable, and they're continually changing. This makes it difficult for refugee and asylum-seeking women and their advocates to keep update with their rights and how to access them. It raised many concerns in terms of international human rights law, specifically right to an effective remedy, and of course, concern regarding the rule of law. In this seminar, we will address that concern, asking what current initiatives offer women in terms of improved protection and how refugee women, practitioners, and advocates can engage with and inform this mechanism.
In the time that it has been allotted, I'm going to cover the following points, I hope. One is I'd like to start off with the broader context in terms of the world at war at this point in time. I'm sure you're all familiar with this, but I want to emphasize the relationship between armed conflict and forced displacement. Then I'd like to move on to the state of international law and international refugee law, which is not very positive these days. And touch upon the blatant violations in terms of international law and the reduction or regression in the number of asylum seekers, at least states blocking asylum seekers. Then I'll touch briefly on the 2016 New York Declaration for Refugees and Migrants. That declaration is still in place, of course, and it takes the multi-stakeholder approach to dealing with mass influx situations. Then I'll touch on the 2018 Global Compact on Refugees and the coordination of international responses to large refugee flows and protracted refugee situations. And then I'll touch on a research topic that I'm doing with Professor Elspeth Guild, who I see is with us today, titled Migration and Human Rights in the Age of the Global Contacts. And it focuses on 4 thematic questions, and I'll try to summarize those very briefly for you. And then I'll have some concluding reflections. So let me start with the broader context. I'm sure you're all familiar with this, but I think it's relevant in terms of the discussion with respect to the situation with the global compacts themselves, but also with refugee status specifically. I think if you look at a number of different indicators, and what I've got on here for you is the Geneva Academy, the Academy of International Humanitarian Law and Human Rights, the Rule of Law of Armed Conflict portal, RULAC, if you're not familiar with this. What they do is they classify all situations of violence that's armed conflict under the international human rights law definitions for this, and they've identified 110 armed conflicts that are taking place in the world today. And you can see that they break down regionally in the following way. The Middle East and North Africa, 45, highest concentration, Africa, 35, Asia, 21, Europe, 7, Latin America, 6. If you look at the UNHCR's flagship annual publication, The Global Trends on Enforced Displacement, that report has identified 123.2 million forcibly displaced persons in 2024. And the report notes, and I want to emphasize this, that displacement has doubled over the last decade. And if you look at UNHCR's 2025 mid-year term report, it says that similar to recent years, 2/3 of the refugees and other people in need of international protection are from just 5 countries: Afghanistan, Syria, Sudan, Ukraine, and Venezuela. The point here is that armed conflict is increasing, the number of refugees are increasing, and the refugees are concentrated, of course, in those areas where there's protracted armed conflict that is taking place. And if we go on to look at the state in terms of international law, international refugee law, you're all familiar, of course, that the situation is far from sanguine, and recent examples in terms of the violation of the prohibition and the use of force that is contrary, of course, to the UN Charter and international law. The ongoing conflict now with the U.S.-Israel attack on military operations with respect to Iran. You have the U.S. operations in Venezuela and the rendition of the president, Nicolas Maduro. You have the Russian invasion of the Ukraine, and you have China's military buildup of South China Sea with military bases. That's been ongoing since 2013, 2014. We're all familiar with the U.S. Trump administration and its systematic dismantling of the asylum system in the United States. And this ostensibly has been done by the United States as an effort to crack down on so-called illegal migrants. But what this is doing is it's a demonstration effect, if you will, a negative example in terms of influencing other countries. And Canada, for example, has passed Bill C-12, strengthening Canada's Immigration System and Borders Act, which was passed on March 26, 2026. And it places a one-year limitation on making claims for asylum. And those people who enter between ports of entry from the United States only have 14 days to make a claim for asylum. What it does essentially is it limits the ability for those people that are seeking refugee protection in Canada. And in addition, it enables the government to cancel immigration documents and remove inactive asylum claims from the system. If you look at the UK, the Border Security, Asylum and Immigration Bill, 2025 Act, it treats asylum applicants as security threats. It imposes a 20-year wait time for permanent residence. It limits refugee status to 2.5 years and makes the status dependent on regular reviews on whether or not the country of origin is safe to return. It removes accommodation and financial supports for certain asylum seekers, and so on. If you look at the general trends in terms of both the United States, Canada, and UK, the effort is to try to reduce the number of asylum applications or claimants. If you look at the New York Declaration for Refugees and Migrants, that was a commitment on the part of the United Nations and its member states to protect refugee rights for all forcibly displaced persons, focusing on shared responsibilities for host countries, ensuring the education of refugee children, and strengthening global migration governance. The two annexes are really important, of course. One is the Comprehensive Refugee Response Framework, and the second is the commitment to establish the two global compacts, the one on the Compact on Refugees and the other Compact for Safe, Orderly, and Regular Migration. The commitment was to implement these or put them into force by 2018, which they succeeded. It's important also to keep in mind that the declaration brought the International Organization for Migration into the UN system to promote greater global migration management. UN member states committed to provide immediate financial and logistical support to countries and communities hosting large numbers of refugees. And it's important to underscore that the Comprehensive Refugee Response Framework charged the UNHCR with coordination with states to develop a multi-stakeholder approach to deal with mass influx situations. And also there was a commitment on the part of searching for durable solutions for forced displacement and which is a key feature of the Comprehensive Refugee Response Framework. If we look at the 2018 Global Compact for Refugees, it's a non-legally binding framework that's designed to strengthen international responses to large-scale refugee flows and protracted refugee situations. The four key interdependent, interlinked, and voluntary objectives of the GCR are to ease the pressures on host states, to enhance refugee self-reliance, to expand access to third country solutions, and to support conditions in countries of origin. And it's important to emphasize that there are three key implementation methods One is the Global Refugee Forum, which is held every 4 years at the ministerial level to allow for pledges of her contributions and shared best practices, and also to assess progress. The other is a support platform, and these platforms are to assist specific refugee situations through the mobilization of political and financial and technical support. And the third is the high-level official meetings, which are held between the GRFs to maintain momentum and to review progress. So as I indicated before, Professor Guild and I have been involved with an MDPI research topic on migration and human rights in the age of the global compacts. And if you're interested in this, I have the link here to the website, and we are still accepting articles for that. But what this particular research topic does is it identifies 4 thematic questions, and I'll touch on each of these, and I'll try to provide a brief snapshot in terms of what progress has been made with respect to these particular thematic areas. The first question is, has there been an advancement in terms of protection for refugee and migrant rights since the adoption of the Global Compacts? There have been advancements, including the structured multi-stakeholder participation, the Global Refugee Forum, and there's going to be one coming up in May, and the expansion of refugee settlement pathways, that's increased. There's a stronger recognition in terms of migrant rights and international law. There's a human rights approach, of course, in terms of the Global Compacts, and it calls on states to respect the inherent dignity of migrants. Nonetheless, the implementation has not been consistent, and some nations, of course, focus more on migration management, such as the United States and other countries, than human rights protection. And the implementation is dependent on voluntary state pledges and monitoring. And one question that you can raise is whether or not we're dealing with root causes as opposed to the symptoms with respect to displacement. Another key question is, has there been any variation in the application and implementation of these global compacts? And what can be learned from one or the other in the progressive development of the rights of refugees and other migrants? Now, there have been significant variations in terms of the implementation of the global compacts, and these are driven by the non-binding voluntary nature, of course, but also political constraints in individual states and the national sovereignty concerns, specifically among some states. One of the central challenges for states is turning these international commitments and support for the global compacts into domestic policy or actions. And despite the fact that the GCR is voluntary, it does build on legal human rights norms, of course, that should make it easier for states to actually implement the global compact's principles and commitments. Nonetheless, there are gaps, and studies have indicated that some of the states have reported that they've fulfilled some of these commitments, but if you look at what they're doing in practice, there's a major gap there. What lessons can be learned from UNHCR and IOM in the way that these particular compacts have been managed? And some of the lessons that have been learned appeared to be the necessity of multi-stakeholder engagements, including non-state actors, the value of formalizing review mechanisms such as the Global Refugee Forum and the other forums I referred to previously. But there's still that remaining extraordinary challenge of merging humanitarian protection needs with state-centric migration management desires. Despite the global compacts not being legally binding, what they proved over time is they are a framework for setting norms, and encouraging state cooperation and establishing best practices. And they demonstrated that their normative authority through voluntary commitments can actually drive action. So what is the future of these unprecedented global compacts with respect to refugees and migrants? The GCR seeks to transform the world's response in terms of refugee crisis, moving from temporary emergency-based responses to long-term sustainable solutions. And the key aspect in terms of the GCR is strengthening burden sharing from low-income and medium-income states that host the vast majority of the world's refugees, nearly 90%, to high-income states through more funding and resettlement pathways. And the Global Refugee Forum is playing an important role in pledging concrete support in 3-year cycles to expand resettlement and other pathways to provide more durable solutions to the world's refugees. And there's an effort as well to strengthen the partnerships between development actors, including the World Bank, to support host states rather than simply the provision of humanitarian aid. Now, we have to be mindful of the serious challenges confronting the global compacts and the world community as a whole, the rising anti-migrant sentiment that's taking place in many regions of the world, the difficulties attendant with voluntary pledges and commitments over a sustained period of time, and not addressing, even though it's recognized, the importance of dealing with the root causes. Now, I'm probably going to go over my time, but I do want to emphasize the fact that the vast majority of the world's forcibly displaced are due to armed conflict, of course. And as indicated previously, this has doubled over the last decade. So as the number of wars increases, armed conflicts increase, the number of refugees will increase. But at the same time, what is happening, of course, are states are restricting access to asylum. So as the numbers increase, the numbers that are being accepted, states are trying to decrease that, at least the high-income states. I'll just end on this particular note in terms of concluding reflections, as I emphasized before, and that is, even though there's been some progress in advancing the rights of refugees and developing institutional arrangements to continue the mechanisms to address large refugee flows that are caused primarily, of course, by the wars and the protracted armed conflicts. And even though there's a recognition that we have to address the root causes, there's been very little effort at addressing protracted armed conflict through these particular mechanisms. And I'll end it there. Thank you very much.
So if I can try to respond to the question that this seminar poses, where are the women? Well, from UNHCR's perspective, what we see is they are on the move all over the world. They're fleeing rampant sexual violence, which is being used as a military strategy in the war in Sudan, relentless bombing in different countries in the Middle East, intimate partner violence and female genital mutilation in countries where state protection against these is inadequate, and unacceptable risks of persecution and human rights violations in other parts of the world as well. They are at borders and in small boats trying to reach safety, often facing pushbacks or other deterrence measures. They're in the courtrooms, challenging restrictive approaches to credibility assessment and narrow interpretation of the refugee definition. And they are braving the odds to try to seek solutions and better futures for themselves and their families. In other words, they are at the forefront of the protection challenges that international refugee law is designed to address. There's no doubt that this is an incredibly difficult time for international refugee law, as James has indicated in regards to a number of developments we see in countries worldwide. The cold climate that the title of this seminar series refers to is reaching freezing point in some countries around the world. We see populist politic rhetoric, which is blaming asylum seekers and refugees for social problems, usually without evidence, and often based on scaremongering that misrepresents the numbers and profiles of people seeking protection. We see increasingly restrictive measures and policies in global north countries, which are placing additional demands on countries in regions of origin of refugees. Failure to manage migration effectively places pressures on many asylum systems, and lack of investment in peace and security in countries of origin makes solutions elusive for too many refugees, including women and girls, whose lives and potential are kept on hold for years on end. Against this background, I want to today highlight 3 areas of significant challenges and gaps which UNHCR sees, which impact on women in particular. But for each, I want also to point to some positive developments or the potential and highlight what we can do, whether as people with lived experience of displacement and statelessness, as advocates, lawyers, civil society, officials, academics, or otherwise, to try to highlight and reinforce the agency and leadership that many displaced women show every day. I'll address firstly, asylum procedures and law, secondly, women in mixed movements, and thirdly, the implementation of the GCR, building on what James has provided as an overview of the framework to talk about the results in practice that we are seeing or not seeing in many parts of the world. So first of all, to speak to women in asylum processes and those seeking international protection and rights through law. We see too many modern state asylum systems which are extremely complex and difficult to access and navigate. For some women, including those who've been traumatized by the persecution they've suffered or their mistreatment on the journey to reach safe territory, it can be extraordinarily difficult to get access to a fair and effective determination of their claims. Legal advice and representation can be extremely hard to come by, notably at first instance. And we see that the specific needs and challenges of women asylum seekers are often not taken into account. This ongoing challenge needs to be addressed by more effective advocacy, by research and analysis, as well as evidence that would point to the benefits, not only for asylum-seeking women, but also for states that would accrue to having access to better information about women's claims and giving them better opportunities to tell their stories and adduce evidence. There are tools which can help. UNHCR, operating in a climate of reduced resources and pressures worldwide, is nonetheless seeking to prioritize work around strengthening the capacity of asylum systems and procedures to do a better job in the face of backlogs and many different complex claims, including those that affect women in particular. And that guidance and capacity development work includes emphasis on gender-sensitive approaches, including policies which seek to ensure that interpreters, interviewers, and decision-makers include women, and that women who are seeking asylum can request and receive access to gender-sensitive, trained expertise, as well as women officials for the purposes of presenting their claims. This also includes emphasis on ensuring that all members of families can get independent opportunities to put their evidence and stories forward, as well as the means to be able to seek support to enable people to deal with immediate needs, whether that's psychosocial, physical, or otherwise. We see some positive developments and trends in some parts of the world. We see on the books in EU legislation explicit recognition of gender-specific forms of persecution based on which EU member states are bound to provide protection to women who suffer these. We also see the provision in those EU laws for specific procedural guarantees for those who need it, which might include people who have suffered trauma through their gender-based persecution or through exposure to risks around trafficking. We see some examples of good practice. If I can point to the practice in Brazil, for example, we've seen a shift to using gender as a specific element to apply differentiated asylum procedures. This involves a simplified process which involves expedited registration and refugee status determination for women who come from countries where FGM is prevalent, amongst other things. And a similar approach is being taken in some countries which do provide specific emphasis on these forms of persecution, where the evidence shows clearly that an international protection need is made out. When women can get into the systems and have an opportunity to have their asylum claims heard, we also have seen in recent years some positive developments with respect to jurisprudence from some leading courts. These are cases where the courts have stepped forward and played a vital role in upholding women's rights in line with international, regional, and national law. I can cite, for example, the case before the Chief Court of Justice of the European Union in October 2024 of AH and FN against the Federal Office for Immigration and Asylum, where the court held that gender and nationality alone are sufficient grounds for a country to grant asylum to Afghan women. This landmark judgment saw the court classifying the discriminatory policies imposed by the Taliban regime against Afghan women as acts of persecution, providing clear grounds for refugee status recognition. And this has been a crucial step in ensuring that Afghan women who have been able to gain protection in instances where they may not otherwise be able to provide detailed evidence of individual persecution. We've also seen from the European jurisdictions the case of WS, also from 2024, relating to 2 Kurdish women from Turkey who were victims of domestic violence. And the court, very importantly there, has set out clearly the test for recognizing this as the basis for international protection needs, with the result that in some jurisdictions in Europe, we see increasing recognitions in such cases. Turning to the Americas, I want to highlight the judgment in the case of Kanyinda by the Supreme Court of Canada, in a case in which UNHCR intervened as a third party, which found that a law denying subsidized childcare for an asylum-seeking mother was discriminatory and unlawful and prevented her from exercising her right to work. This important judgment went not to the criteria for granting of protection, but to the rights that should be available to people both awaiting asylum determinations as well as those recognized, finding that this discriminatory provision should be struck down as contrary to Canada's international obligations. So whilst we face an extremely difficult landscape, there are some positive glimmers of hope that should be emphasized and brought out more clearly, including as good practice. Let me turn to my second area now, which relates to the situation of women who are on the move in mixed movements. Even before they secure access to territory and asylum systems, we see a crucial issue arising in regards to whether women can get access to protection to safeguard their basic physical safety. And in this regard, UNHCR has undertaken research and analysis of movements along the Atlantic, so-called Atlantic route from sub-Saharan Africa to West Africa and North Africa and on to Europe. And this is research which is focused specifically on the situation of women in mixed movements, noting that an absence of sufficient gender disaggregated data and gender focused research in this area doesn't give us a clear enough picture about whether or not access to safety and rights is available for people who are traveling these dangerous routes. Looking at Mauritania, Senegal, Mali, Niger, and Burkina Faso, the mapping showed that there was availability of services in urban hubs and particularly national and regional capitals, but there are key mixed movement locations which remain severely underserved, including border areas, remote transit zones, and coastal departure points. These are precisely the locations where protection risks are highest and where women and girls in particular need support. In terms of the kinds of services that are available and the gaps that arise, we noticed in particular that gender-based violence services along routes are uneven and often limited to large urban centres. And this can mean that survivors can't access the package of care that they need, pushing them often to move further onwards or to remain in unsafe conditions. And this is something which has worsened significantly over the last 18 months with reductions in humanitarian aid. We see access to asylum procedures, legal assistance, and trafficking-specific support is also available in many cases around capitals or large towns. And despite the efforts of local actors in other areas, this is insufficiently available for too many women that need it. On the positive side, we do see that there are some frontline and community-facing services, including identification and outreach, health and mental health and psychosocial support that is increasing, including notably through the effort of local organizations, including faith-based actors and others. And the research shows that whilst protection frameworks are in place in some key countries along movement routes, these are fragile and their weaknesses affect women and girls first. There are in that research, which I commend to anybody who's interested in this area, some positive gender-related initiatives, highlighting, for example, if I can, a community protection network in Mauritania, including women-led and community-based organizations, which is training and carrying out effective identification, referral and support, particularly to trafficking victims. And we also see some important work in regards to gender-based violence and mental health and psychosocial support in Niger, one of the world's poorest countries, which is hosting vast numbers of Sudanese refugees, and where local organizations are doing what they can to ensure that women can get access to protection that the state is not able or willing to provide. Let me turn to my third area then, with regards to gender commitments under the Global Compact on Refugee. So 2 points here to make. Firstly, that despite some important positive wording in the Global Compact on refugees around women and girls, we see a persistent gap between the gender commitments that are set out in that compact and their uneven implementation in practice. There's clear commitments in the Global Compact around gender equality, inclusion, and refugee participation, including with a focus on women and girls. There have also been a number of important pledges made by some countries, but nonetheless, progress remains uneven across many contexts, and it's highly vulnerable to the funding cuts we've seen in recent years. Secondly, even where women and girls are able to obtain protection, what the implementation of the GCR shows us is that solutions for them continue to lag behind solutions for men, and that without access to solutions, protection, of course, remains incomplete. I'd commend those who are interested to look at the Global Compact on Refugees Indicator Report 2025, which UNHCR has issued, which highlights that there continues to be barriers which are in place to self-reliance, including access to decent work, education and services, in particular impacting upon refugee women who are also facing in many instances discrimination and other barriers that make this additionally challenging. On the positive side, what we have seen through the process around the Global Compact is increasing numbers of women's voices being amplified in international fora. This includes their physical presence and participation in GRF-related events. There's some 300 people with lived experience of displacement who attended last year's GRF Progress Review, including a number of extremely articulate and charismatic women leaders. But we need to make sure that their involvement is not going to be tokenistic or merely for show, but is actually going to amount to meaningful participation in decision-making processes. And I'm sure we'll hear more from Anna Maria about that. So in conclusion, what can be done to make these problems more visible, but also some of the positive approaches and potential solutions to become more widely known and discussed? Well, I think there's things that all of us can do in our respective roles. Lawyers can do more to ensure effective, high-quality advice and representation, including access to courts to ensure that precedent-setting judgments that focus on gender aspects of protection can be handed down. Decision makers and national authorities can hold.
I am very, very honored to be part of this critical discussion, because when we ask this question of where are the women in refugee law and also in the compliance of the Global Compact, I am a woman that has navigated these spaces, and I know for far too long that our presence has been noted, but our voices have been sidelined. And I want to share a very personal experience. I am the president of a network that brings together over 100 NGOs. So picture how massive this is. It's 100 NGOs with their own teams, their own expertise, with different countries of residence. And I have to balance all of these critical issues and everyone's demands. And one of the things that caught my attention when I was recently elected president was how many women were actually leading those NGOs. And I ran an assessment, and over 70% of the NGOs throughout Latin America and the Caribbean region were led by women. And also in the humanitarian field, it was the same. But not every single one of them were in a decision-making position, not even within their own NGOs. So this is an overall picture of how the world is functioning right now, and of course how the women voices are being sidelined. But when we talk about refugee policies, we are talking about something beyond the humanitarian action or being in the field. It's about laws that are governing our access to rights, our bodies, our families, our possibility to have a safe path in a different country that it's not our country in origin. And this is a persistent gap where a gender lens should be used. And whether we are refugees or asylum seeker or forcibly displaced women, hold this massive knowledge about the field, this intimate, direct knowledge of our communities, because we are the first responders. We know which services work, we know which protections are failing, and how to navigate the barriers that others might not even see. And we are excluded from policy making, which is the gap between having this knowledge of what is not working and make it possible. And this just bring incomplete laws, and I've seen it many times in policy making in Latin America specific, how a policy can fail for not being consulted with people with lived experience. And that's why I am proud to introduce the Independent Declaration of the Right of Persons with Experience of Forced Displacement or Statelessness on participating in decisions that affect them. And we will call it the Jakarta Declaration on the Right to Participate because the name is too long. And also because this final draft was discussed in the city of Jakarta. So it was an honor to have this name. But this is not just another institutional document drafted in a vacuum. It's a rights-based framework co-owned by a global community of people who, like me, have experienced forced displacement or statelessness, but also bring scholars, bring academics, bring civil society members. It's a 19-person working group that we sit together for 2 years to draft this independent declaration to establish a new standard. And it's independent, deliberated, called independent, because we don't want to own it. We want people to own it, to use this as a trailblazer, to establish a major tool for those legal voids that we find often in our countries. And I can talk about, for example, the Cartagena Declaration, that it's supposed to protect many people in Latin America. And I am a Venezuelan, and Professor James also mentioned several times the Venezuelan crisis. And we have a very, very wide legal gap in here within the Cartagena Declaration that covers people for protection scope if they are fleeing for persecution, for violation of human rights. And yet, because of a legal gap in most countries in Latin America, this cannot be implemented. And this is something around that we can discuss in a separate session. But for the Independent Declaration is a specific document that broad the scope for participation and brings participation as a right, not an option. And this is very important because very often our opinions on how a policy can affect our life or can be improved is just perceived as an option and a goodwill from the governments that are implementing, but actually should be a right, because the decisions that affect our lives and our access to rights, it's very important, it's critical for us. So it's a way to end tokenism. We all have experienced symbolic participation, and you can see through the document this in the language on which we drafted. The many spaces is only for the sake of a photo or for a report, but the Jakarta Declaration explicitly rejects this superficial engagement, and yet it demands meaningful participation that carries actual influence over the final outcome. And for us as women, we are 9 women in the working group, and many of us, we are lawyers also, but also practitioners. Meaningful participation is about more than just representation. It is about efficiency, it is about dignity. And when we lead, we bring solutions that are grounded in reality. We identify the gaps in protection that top-down approaches that very often are missing. And this is in closing the Jakarta Declaration. It's an invitation for you all, that policymakers, advocates, scholars, to move beyond simply consultation with us. It is a roadmap in which we ensure that our voices are no longer an optional addition. It is a foundation of international protection. When we started this drafting process, it was 32 long articles, and we narrow it to 5 articles. I will be sharing through the chat box the link to for you all to check on the independent declaration. We have 2 version of it, and it's also in Spanish and English, but it's 2 different versions of it. One, that it's the simple document with 5 articles that goes from how participation should look like, how to access information about good faith and no discrimination, supporting and resourcing participation, and also the right to remedy and accountability. It's 5 articles that also have a second version with commentaries. And within those commentaries, you can see how international law has been embedded in this document to also offer a pathway to how to ease the way and to make it possible not only for policymaking in the legal scope, but also how we can advocate for more changes like this within our system, within our own organizations, and also to open the door for more in-depth conversations like this. You can find also the document about consultations, because we drafted, but we did a massive consultation throughout all regions to make sure that we were capturing the true essence of people in the ground. And you can see the document on how this was developed. But in as a closing remark, we are moving forward, and we have to make sure that when we ask where are the women's, we will have this answer that we are in the table, we are doing policy making, we are leading the way, and we are wearing these lenses, these gender lenses, in the changes that we want to see in the world. I'm open to some questions if you have it, but please check out the website for the document with and without commentary, and feel free to endorse the independent declaration as well. Thank you so much again for this wonderful invitation.